I had mentioned earlier that when we're talking about what kinds of things will, life changes will have an impact on your estate plan, one of the most important life changes to an elder law attorney who is trying to protect you, your family, and your assets is when you tell me you have a diagnosis. Somebody has a diagnosis in the family. Cognitive decline, dementia becomes more and more common as people age. And if that's what we're dealing with, the likelihood is that we're going to be looking at memory care or some kind of long-term care. People like to, take care of their loved ones in their home as long as they can often, but at some point in time, a facility-based care is needed. So we want to plan for that. So to plan for that, as an elder law attorney, I want to make sure that the durable powers of attorney have necessary, specific authority that will allow Medicaid asset preservation strategies to be implemented. Those often involve changing ownership of assets, titling. They involve gifting assets beyond just what the annual exclusion gifting amount of $17,000 is. We might want to gift to a trust or gift to family members. But because of Medicaid's rules, we're often looking at doing some strategy that prepares for long-term care during people's lifetimes. And through gifting of assets, we're actually able to preserve and protect assets, which I know sounds kind of counterintuitive, but it is the case. And there are really good Medicaid strategies that exist, all depending on what your situation is. But when we're trying to help clients and they have what I'll call bad durable powers of attorney, ones that say no gifting, there's nothing we can do at that point, really. So having good durable powers of attorney with specific authority is really important to an elder law attorney. When we're talking about couples and perhaps one of them or even both of them has some diagnosis that is going to make it likely that they're going to need long-term care, we want to make sure that their wills have been updated and include what is called an asset protection supplemental needs trust. What that is a trust that protects assets for the surviving spouse. So when one spouse dies, their assets go through their will, through the probate, into a supplemental needs trust for the surviving spouse. And here's just a really simple example. Let's say the couple has $1 million. I choose that. It's easy to divide by 2. The first spouse dies. Everything is community property. $500,000 will go through the deceased spouse's will through the probate process and fund the supplemental needs trust that is created through the will of the deceased spouse. That $500,000 is for the benefit of the surviving spouse. And when that surviving spouse needs long-term care, Medicaid will pay for that care, even though they have $500,000 in trust. That's how Washington's Medicaid rules works. So if $500,000 was in an investment account, liquid, banks, savings, etc., $500,000 in the house, when the first spouse dies, we'll take the liquid investments, $500,000, put it into the trust for the survivor. The surviving spouse owns a house and they have $500,000 in a trust. If they need long-term care, they can immediately qualify for long-term care that Medicaid will pay for, despite the fact they own a $500,000 house and they have $500,000 in this trust. They have $1 million worth of assets accessible to them, the house, which they own, and what's left, the money in the trust, which doesn't count. From that example, I think you can see why it's so important to understand that couples have an excellent planning tool to protect the surviving spouse against impoverishment because money in this trust simply does not count against them for Medicaid before the state will pay for their care.